welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by LiveLaw. I'm your host, Ostika Das, and I'm here to take you through the most significant updates from this week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. But remember, for a more in-depth understanding, do visit our website at www.livelawmedia.in. In today's episode, we are going to talk about Delhi Chief Minister Arvind Kejriwal's arrest, AAP leader Manish Sisodia's bail plea, Baba Ramdev's apology before the Supreme Court for misleading advertisements, and much more. So let's dive into the headlines. Let's first delve into the significant developments this week concerning the Delhi liquor policy case. The Delhi High Court, through a bench of Justice Swarnakanta Sharma, upheld Delhi Chief Minister Arvind Kejriwal's arrest and subsequent remand in the money laundering case linked to the alleged Delhi liquor policy scam. The court emphasized that the evidence collected by the Enforcement Directorate indicates Kejriwal's involvement in formulating the excise policy and utilizing the proceeds of crime. Kejriwal's argument against vicarious liability due to the Aam Aadmi Party's status was countered by the court, citing Section 70 of the Prevention of Money Laundering Act, or PMLA. One of the arguments raised by Kejriwal was regarding the timing of his arrest just before general elections. Addressing this, the High Court said that legal scrutiny must follow irrespective of election schedules. Notably, Justice Sharma clarified that Kejriwal would have the opportunity to cross-examine approvers at the appropriate stage. Following this, Kejriwal swiftly approached the Supreme Court, challenging the Delhi High Court's decision. His counsel, Senior Advocate Abhishek Manu Singhvi, alleged that the High Court's verdict was based on an unrelied document which was suppressed from Kejriwal. The matter was mentioned before Chief Justice D.Y. Chandrachud for urgent listing. However, the Chief Justice did not specify a date for posting. In another related development, the Delhi High Court rebuked former Aam Aadmi Party MLA Sandeep Kumar for repeatedly filing petitions seeking Kejriwal's removal as Chief Minister of Delhi. This marks the third such petition, with previous pleas already rejected. The bench, comprising Acting Chief Justice Manmohan and Justice Manmeet Pritam Singh Arora, imposed a cost of Rs 50,000 on Kumar. Expressing the judiciary's reluctance to wade into political matters, the bench said that the governor would take a call on this. Next, we turn to BRS leader K. Kavita, who has also been arrested in connection with the Delhi liquor policy scam. A Delhi court has denied her request for interim bail this week. Special CBI Judge Kaveri Baweja dismissed Kavita's plea, citing prima facie evidence of her active participation in alleged money laundering, evidence tampering, and attempts to influence witnesses. The court highlighted that Kavita, being a well-educated and prominent figure in society, cannot be considered a vulnerable woman susceptible to being used as a scapegoat. The evidence presented in court, according to the judge, indicates her active role in the alleged offences, including the deliberate destruction of evidence and attempts to influence case witnesses. Kavita, who was remanded to judicial custody till 9th April on 26 March, was arrested on the evening of 15th March by the Enforcement Directorate following searches at her Hyderabad residence by the ED and Income Tax Department. Initially, she was remanded to ED custody till 23rd March, which was then extended by 3 days. The Bharat Rashtra Samiti leader and daughter of former Telangana Chief Minister K. Chandrasekhar Rao was in judicial custody till this week, when she was sent to CBI custody for 3 days. Former Deputy Chief Minister of Delhi and Aam Aadmi Party leader Manish Sisodia has approached a Delhi court seeking interim bail for the Lok Sabha election campaign. Sisodia, currently in judicial custody in connection with the alleged liquor policy scam, appeared before Special Judge Kaveri Baweja at Rouse Avenue courts. The Enforcement Directorate and the Central Bureau of Investigation requested time to file their responses. The court has consequently asked for ED and CBI's replies to the interim bail plea, listing the hearing for 20th April. Sisodia, along with others, is accused of playing a key role in the decision-making process of the 2021-22 excise policy, allegedly favouring licensees post-tender. Despite attempts for bail, including appeals in the trial court, Delhi High Court and Supreme Court, all have been denied. The Supreme Court also dismissed his review petitions against the bail deniers along with curative petitions. Currently, Sisodia's second bail plea are pending before the special judge. The National Investigation Agency has approached the Calcutta High Court regarding attacks against its officers in West Bengal's Bhupatinagar. These attacks stem from the agency's investigation into a 2022 case involving blasts in Bhupatinagar, East Midnapur. If you remember, the Calcutta High Court is also hearing a plea against the alleged attack on Enforcement Directorate officials by Shah Jahan Sheikh's associates in Sandeshkhali. According to the NIA, its officers were attacked while on duty when they had detained two local leaders for questioning related to the case. The agency alleges that state police subsequently registered FIRs for molestation against the NIA officers who were targeted by the accused's family members. Local reports indicate that the attacks were allegedly triggered after the NIA detained two Trinamool Congress leaders in connection with the blasts. The case will be heard by a single bench of Justice Jay Sen Gupta at the Calcutta High Court. And stay tuned for further updates on this matter. Next, we turn to an important update regarding the Sandeshkhali violence. The Calcutta High Court has directed the Central Bureau of Investigation to conduct an investigation into allegations of rape and land grabbing by miscreants influenced by local leader Shah Jahan Sheikh in West Bengal's Sandeshkhali. The court has specifically instructed the CBI to provide a report for a court-monitored inquiry into these serious allegations. Previously, a division bench comprising Chief Justice T.S. Sivagnanam and Justice Hiranmaya Bhattacharya had already transferred the probe into an alleged attack on Enforcement Directorate officials by Shah Jahan's associates in Sandeshkhali to the CBI. Now, the court is considering the various public interest litigations requesting an independent probe into the rape and land grabbing allegations, which gained attention following the attack on the ED convoy that made national headlines. This week, the Supreme Court declined to hear Aam Aadmi Party MP Sanjay Singh's plea challenging summons issued to him in a defamation case regarding remarks on PM Modi's academic degree. This case stems from a defamation complaint filed by Gujarat University against Delhi Chief Minister Arvind Kejriwal and Sanjay Singh. The complaint accused them of making defamatory statements targeting the university over PM Modi's degree, both in press conferences and on Twitter. Last year, summons were issued to Kejriwal and Singh to appear before a magistrate court in Ahmedabad. Their plea for a stay of the trial was rejected by the Sessions Court. They then approached the Gujarat High Court against the summons and the Sessions Court's decision, seeking a stay on the trial. In October, the High Court issued notices but refused to stay the trial. Kejriwal's plea against this was rejected by the Supreme Court, which stated that the High Court was already seized of the matter. Singh also approached the Supreme Court with a prayer to transfer the trial outside of Gujarat, but this too was denied. In February, the Gujarat High Court dismissed their pleas against the Sessions Court order affirming the summons. While hearing a plea against this verdict, the bench of Justices B.R. Gavai and Sandeep Mehta said that the High Court had already observed that all contentions were open to the parties and the trial judge should not be influenced by any prior observations. This week, the Supreme Court made a significant ruling regarding the disclosure of assets by candidates contesting elections. A bench of Justices Aniruddha Bose and Sanjay Kumar upheld the 2019 election of independent MLA Kariko Cree from the Tezu Assembly constituency in Arunachal Pradesh. The case originated when the Congress candidate who lost the 2019 election challenged Cree's victory through an election petition. It was alleged that Cree had not disclosed 3 vehicles owned by his wife and son and also failed to mention his occupation of a government-allotted MLA cottage in Itanagar. The High Court had annulled the election, but Cree appealed to the Supreme Court. The Supreme Court in its latest ruling stated that candidates are not required to disclose all movable assets unless they are of substantial value or indicate a luxurious lifestyle. The non-disclosure of vehicles by Cree was deemed not to be a corrupt practice under the Representation of the People's Act. The court found that the vehicles had either been gifted or sold before Cree filed his nomination and therefore could not be considered as still owned by his family members. The court emphasized that a voter's right to know is not absolute and candidates maintain their right to privacy, particularly regarding matters unrelated to their candidacy. This ruling sets a precedent for election candidates regarding the extent of asset disclosure required during their campaigns. This week, the Supreme Court intervened in the trial against Tamil Nadu Rural Development Minister I. Periyaswamy, staying the proceedings in a corruption case. The case dates back to Periyaswamy's tenure as the Minister for Housing in the DMK cabinet between 2008 and 2009. It is alleged that during this time, he conspired with others to illegally obtain a high-income group plot in a scheme of the Tamil Nadu Housing Board, which was allotted to C. Ganeshan, the personal security officer to then Chief Minister M. Karunanidhi. Initially, the trial court had discharged the minister, but the High Court's single-judge bench of Justice Anand Venkatesh, through suo motu revision, set aside this order. Additionally, the High Court ordered the trial to be transferred from the Special Court for cases under the Prevention of Corruption Act to the Special Court for the trial of cases against MPs and MLAs. It's worth noting that Periyaswamy's case was one of the several suo motu cases of corruption taken up by Justice Venkatesh. This week, a bench comprising Justices Rishikesh Roy and Prashant Kumar Mishra heard Periyaswamy's challenge against the High Court order and directed for the stay of the trial until the next date of hearing. The court clarified that it was assessing the merit of the High Court's judgment, hence the trial should not proceed in the meantime. This week, the Supreme Court granted permission to Uttar Pradesh MLA Abbas Ansari to attend a Fatiha ceremony in respect of his father, Mukhtar Ansari. Mukhtar, a former gangster turned politician, passed away on 28 March due to a cardiac arrest while serving a life sentence. Abbas, currently in jail over an arms license case, had initially filed a petition to attend his father's funeral rites, but the plea couldn't be listed in time. On the last date, he was allowed to amend the petition and provide a copy to the state of Uttar Pradesh, the respondent in the case. The state strongly opposed the plea, citing Abbas's history of criminal activities which led to his transfer from Chitrakoot jail to Kasganj jail. Additionally, they claimed that there was no scheduled ceremony for the next day and that they hadn't received the application seeking permission for the Fatiha. Abbas's counsel, senior advocate Kapil Sibal, objected to these claims. After hearing both sides, the bench directed that Abbas be taken to his hometown to attend the ritual on the same day and be brought back to Kasganj jail by 30th April. The bench also noted Sibal's assurance that Abbas would not engage with media persons and would only visit his family members. This week in the Supreme Court, the contempt case against Patanjali Ayurved over misleading advertisements took a significant turn. The bench of Justices Hima Kolhe and Ahsanuddin Amanullah refused to accept the latest affidavit filed by Patanjali and its MD. This affidavit expressed an unconditional and unqualified apology for airing advertisements in breach of an undertaking given to the court last November. The court further rejected an apology affidavit from Patanjali co-founder Baba Ramdev, who is also facing contempt proceedings. Solicitor General Tushar Mehta informed the court that he had advised Patanjali's lawyers to withdraw the first affidavit, which, if you remember, was conditional, and file an unconditional one. However, the bench found the new affidavit unconvincing, remarking that it seemed to exist only on paper. The court was also critical of Patanjali MD and Baba Ramdev's attempts to avoid personal appearance by falsely claiming to be travelling abroad. During the hearing, the court scrutinized the state of Uttarakhand for its licensing authority's failure to take legal action against Patanjali and its subsidiary Divya Pharmacy. The bench questioned why it should not perceive the authorities as being hand in glove with Patanjali and Divya Pharmacy. After hearing all parties, including the Joint Directorate of Uttarakhand State Licensing Authority, present in court, the bench directed the former Joint Director to submit an affidavit within 2 weeks. This affidavit should explain why no action was taken during his entire tenure. Additionally, all district Ayurvedic and Unani officers from 2018 to the present were instructed to submit similar affidavits. For more details on this courtroom exchange, you can visit www.livelaw.in. This week, the Supreme Court intervened in the controversy surrounding board exams for students of 5th, 8th, 9th and 11th standard in schools affiliated with the Karnataka State Board. Last October, the Karnataka government issued notifications appointing the Karnataka School Examination and Assessment Board to conduct exams for these classes. However, a single judge of the Karnataka High Court nullified these notifications. The government then appealed to a division bench which stayed the single judge's ruling. In response, organizations representing private schools and parents approached the Supreme Court, challenging the division bench's order. During the hearing this week, the petitioner's counsel reminded the bench of the Supreme Court's previous preliminary observations against conducting board exams for these classes. They also highlighted a directive from the Karnataka State Quality Assessment and Accreditation Council issued on the evening of 4th April, instructing students to release results before 9 a.m. on April 8th, presumably to avoid the Supreme Court's scrutiny. The bench of Justices Bela Trivedi and Pankaj Mittal called it a classic instance where the state government of Karnataka has tried to create havoc and great distress not only for the students but also the parents and also for the teacher and school management. The bench further observed that the High Court's order did not seem to align with the Right of Children to Free and Compulsory Education Act or the Right to Education Act 2009. As a result, the Supreme Court has stayed the division bench's order, putting a halt to the board exams for now. This week, the Supreme Court issued notice on a public interest litigation highlighting the need for central legislation to recognize the rights of intersex children and persons. Intersex individuals are born with a mix of male and female biological traits, not fitting into the typical male or female categories. The PIL specifically focuses on curbing sex reassignment surgeries performed on intersex children before they reach the age of majority. The petitioner emphasized the discrimination faced by intersex children from birth, citing issues such as their inability to register their birth and death details on government applications, exclusion from census representation, and lack of recognition as voters. Of particular concern was the practice of sex determination surgeries performed with parental consent in various states. Notably, the Madras High Court in Tamil Nadu has banned such surgeries until the child reaches an age where they can provide informed consent. The PIL underscores the necessity for a legislative framework to address the challenges arising from medical interventions on intersex children. The bench, consisting of Chief Justice Chandrachud and Justices J.B. Pardiwala and Manoj Mishra, has issued notice in response to the petition. This development is significant in recognizing and safeguarding the rights of intersex individuals who are born with bodies that do not conform to traditional definitions of male or female. And that's a wrap for this week's Legal News Roundup. Before we bid adieu, the entire LiveLaw team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audiovisual format, we rely on your support. So here's a fantastic 6 for you. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates, and colleagues to spread the knowledge. Make sure you subscribe to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments below. We love hearing from you. Don't forget to tap that bell icon to stay updated with our latest releases. And lastly, make a quick visit to our website at www.livelaw.in for our in-depth reports and analysis. I'm your host, Ostika Das, and it's been a pleasure bringing you this week's legal updates. Until next time, stay informed, stay engaged, and stay tuned to LiveLaw. Thank you for watching.